state your full name?
In 1950, a war broke out in my home country, South Korea. I was only 9 years old. This experience changed my life. I will never forget passing hundreds of bodies lying on the street. 60 years later, as the president of the ICC, I met with victims. When I met with these survivors of atrocities, I once again asked myself, how can such cruelty be committed by human against the human in the 21st century?
In January 2002, the ICC was established as the first permanent international criminal court with jurisdiction over the most serious crimes of concern to the international community.
Et je pense que dans ces procès où beaucoup de gens disent lutte contre l'impunité, moi je réponds lutte contre l'impunité, mais procès équitable.
Fair trial is a cornerstone of a court. So a court with no fair trial is not a court. For me, I'm ready to die to protect defense rights.
All right, veuillez vous lever.
Well, the presumption of innocence is fundamental to fair trials in democracies, and it's based on the assumption that if the state brings a case against somebody, it should have sufficient evidence, and therefore it has the burden of proving what its case is, and that carries with it the corollary that the person concerned is presumed innocent until proven guilty by the prosecution.
I am not guilty to all charges.
Et je le dis, la présomption d'innocence n'existe plus, en particulier dans ces... Il me semble que dans ces dossiers-là, où c'est la communauté internationale qui regarde effectivement l'accusé, la présomption d'innocence n'existe plus. On a le sentiment que on a vu Thomas Lubanga sur toutes les télévisions comme un chef de guerre. Il y a à aucun moment dans la manière dont on présentait l'accusé l'idée qu'il pourrait être innocent. Donc je pense que dans ces dossiers-là, en particulier, il y a au départ une présomption de culpabilité.
Thomas Lubanga denies he recruited an army of child soldiers.
Whatever the charge, whatever the public clamour of let the individual hang, let the individual spend a life in custody, a court must be dispassionate, and it must view the allegations only in relation to evidence adduced at trial, not upon media speculation or external forces.
The prosecutor at ICC had to serve justice and had to really investigate the truth. And we had to investigate if the person is innocent. We had to investigate carefully that because it's not our role to present charges against someone who is not responsible for the crimes.
Within the statute governing the ICC is a positive duty of the prosecutor to investigate both incriminating and exonerating evidence. This is aimed at balancing the inequality that often exists between the prosecution and defense in investigative resources.
The danger of a prosecutor that is supposed to be objective is that people could argue, well, then we need less powerful defense, because if the prosecutor is already looking for all the exonerating evidence, the defense should not have that many investigative powers, for example. And that would be a big mistake.
And Your Honours, all we can do is to try to challenge that evidence and show Your Honours.
The defence always needs to be cautious, because whilst the prosecution have the burden of proof, the defence needs to be ever vigilant in testing the evidence, put forward its own narrative, and so the judges can see the full allegations in their complexity.
But the prosecution have failed to discharge their burden of proof.
Interim release is the release of an accused person, but the person who is still presumed to be innocent, prior to and or pending his trial.
When judges decide whether to grant interim release, they must be satisfied that the accused person will attend trial, that the person will not jeopardize or interfere with the ongoing investigation, and that the person will not commit ICC crimes.
The registry takes all necessary measures in order to facilitate the implementation of decisions on interim release. However, to date, the ICC has not concluded any agreement with any states on this provisional release. This will make very difficult the implementation of any orders of the Chamber on this issue.
So there's always going to be a tug of war between what the court wants and what states are willing to provide. But state parties that have signed up to the Rome Statute must not be seen, for their own sake, as being only desirous of convictions or only desirous of incarceration, because tomorrow it may be their suspects and their state officials that are at risk.
Publicity of proceedings is a core component of any fair trial. Justice must not only be done, but also seen and understood to be done.
N'oubliez pas que les crimes qui sont reprochés aux accusés, ce sont des crimes de masse. Ce sont des crimes qui se commettent à une très grande échelle, et il est important que la communauté internationale qui veut combattre l'impunité puisse être informée, puisse être tenue au courant de tout ce qui se passe au niveau de la Cour pénale internationale, pour laquelle elle a tant investi pour combattre l'impunité.
From the point of view of the defendant, it's important that trials are held in public. You don't have a star chamber. You have judges acting not only fairly, but publicly fairly. The only reason why trials should not be held in public is in exceptional circumstances to protect the identity, for example, of children or possibly rape survivors, or national security.
When witnesses come to testify, one of the measures that we take, amongst the many measures, is to say that this witness cannot be heard in public.
Your Honor, Madam Witness.
Sometimes even what the witness says can expose other people. We have the duty to also protect those other people, even if they don't come directly before the court. So this is why we go into private sessions.
The ICC offers something quite new for victims of international crimes for the first time. They can participate in court proceedings, which was a key innovation of the Rome Statute. At the same time, the creators of the ICC made sure that victim participation does not occur at the expense of the rights of the accused.
It does have resource implications for the defense, because one may be compelled to respond to numerous filings from disparate legal representatives on many different issues, taking different strands, and it can actually dilute the resources of the defense, because the primary target of the defense must always be the allegations put forward by the prosecutor. And so there are resource implications.
You cannot push under a pressure a defense. You disorganize totally a defense, focusing on the participation of victims. And this is not the main debate. The main debate is between the two parties, even if we have full respect for the right of the victim. The time of justice is naturally long. So you can be fast, but you will not respect all the rights of the parties and the participants. Is it the interest of the defendant to have a very quick trial in an international level? I really don't think so.
Le temps est forcément beaucoup plus long pour plusieurs raisons. D'abord parce que le dossier est extrêmement volumineux en règle générale. Je pense que dans le dossier Lubanga, on est arrivé à peu près à 30 000 pages. Deuxièmement, pour aller enquêter, il faut qu'on aille sur le lieu des enquêtes, c'est-à-dire à quelques milliers de kilomètres de La Haye. Et ça aussi, ça prend énormément de temps. Et y compris à l'intérieur même du pays lui-même, pour enquêter, les transports sont très délicats et tous les moyens de communication sont difficiles. Donc tout ça entraîne évidemment un temps relativement beaucoup plus long que dans une juridiction nationale.
Every defendant has the right to have a counsel of his or her choice. The registry maintains a list of highly qualified counsel authorized to practice before the ICC.
C'est la communauté internationale qui veut vous traduire en justice. Et donc, vous vous rendez compte, le challenge pour la défense, c'est de se dire, nous, on est les seules personnes qui pouvons, à un moment donné, véritablement être le rempart à l'arbitraire, à l'injustice. C'est très important, fondamental.
The legal aid system has been created to ensure that every person can have this assistance and that the persons working as lawyers, as legal assistants, as case managers can receive a fair remuneration.
J'estime que cette aide juridictionnelle est décente, c'est-à-dire qu'elle est assez suffisante pour me permettre de mener à bien le travail qui m'a été confié, parce que je bénéficie des ressources qui s'imposent pour avoir une équipe. Donc j'ai une équipe avec un co-conseil, 2 assistants juridiques et un gestionnaire de dossier et 2 personnes ressources.
Nous sommes une équipe de 4 avocats. Nous devons faire les enquêtes, répondre aux 2700 procédures qui a été dans notre dossier, un nombre considérable de témoins. Nous sommes 4. Je pense que c'est difficile. Notre équipe, on a vraiment travaillé aux limites de ce qu'on pouvait faire.
The IBA and the ICC launched a joint campaign to encourage eligible lawyers to apply for admission to the ICC List Counsel and List of Assistants to Counsel.
I'm actually very proud to be on the list of assistants, and I pray that one day I go to any of the maybe defense teams as an assistant. I can't wait, I'm very anxious.
When considering whether you should get involved with the work of the ICC, remember that there are many opportunities for legal professionals depending on their expertise, depending on their practical experience.
I've done it myself. It has been a wonderful experience. You learn a lot. You can use it for your research, and also defense teams can make use of knowledge and expertise of academics.
So come and join the list of counsel.
Tasajali, tasajel.
Hurry up.
Nous avons besoin de votre contribution.
Join us.
Join the list.
The ICC is waiting for you.